Mr. Spear?
May it please the Court, I'm Brownlow Spear, and I represent Mr. Alvin Suliveres, who is the designated appellant in this matter. It's here on the reservation and report of a single justice. Mr. Suliveres was put to trial on a charge of rape in Hampden County. The trial ended in a mistrial when the jury couldn't agree on a verdict, and the case is here on the reservation and report by the single justice of Mr. Suliveres' double jeopardy claim, that is, that to retry him would violate his rights not to be put in jeopardy a second time, based on our contention that taking the Commonwealth's evidence in the light most favorable to it, that evidence was not sufficient to withstand Mr. Suliveres' motion for a required finding of not guilty at the close of the Commonwealth's case. And specifically, we claim that the Commonwealth's evidence failed completely on the necessary element of force, which this Court, in the 2001 case of Lopez, held as an element separate from the element of variously described of against the will or lack of consent, and must be proven in addition to the lack of consent element.
Let me ask you this. Would you take the position that the defendant could have been guilty of a lesser offense? Let's say assault?
Your Honor, that question has taken me a little by surprise. I hadn't anticipated it. The old English case law on this subject, some of those cases do say that the defendant could be convicted of a lesser included offense of assault, I think assault and battery.
You can get back to us on that.
That might be the case. I had not actually thought of that question in advance.
Well, why don't you get back to us afterwards on that? Send us a letter.
All right, Your Honor, I will. The Commonwealth's case in the light most favorable to it is that the complainant had sexual intercourse with Mr. Suliveres in the mistaken impression that he was her boyfriend, Mr. Suliveres' brother, and that Mr. Suliveres knew that the complainant was mistaking him for the boyfriend, so that this sexual intercourse is produced by fraud. But it's the established law of this jurisdiction that the rule of the Goldenberg case, the 1959 case of Commonwealth versus Goldenberg, that fraud, and I'm quoting from the language of that case, that fraud cannot be allowed to supply the place of the force which the statute makes mandatory.
If we, I know I'm sure you've anticipated this, if we overrule Goldenberg, can we apply it to this case?
I think not, Your Honor, and I think...
Is that kind of like ex post facto lawmaking?
Right, I think not for two reasons. One is the first is the provisions against ex post facto laws of the federal and our Constitution. And going to the leading case of Calder versus Bull, which this Court frequently cites, most recently in the case of Maloney last year, the first category of Calder versus Bull was that every law that makes an action done before the passing of the law and which was innocent when done criminal and punishes such action. Now, our state constitution is very close to that language.
Yeah, your brief and Mr. Townsend's brief don't cover that question at all, whether we could, if we overrule Goldenberg, we could reapply this, so...
Yes, my first point would be the ex post facto clauses, and I should add to this that in the case of Morera, which was 388 Mass 596 at 601, this Court, of course, ex post facto was talking about statutes, but in Morera, the Court said that it would be fundamentally unjust to render criminal by an overruling decision conduct which was not criminal when it occurred. This would be equivalent in effect.
Do you want to send us a letter on that point, too?
I'll be glad to, Your Honor.
I get a little nervous if we get to this point of, dealing with an issue that hasn't been briefed at all.
I will send a letter.
Because it hasn't been briefed, has it?
No, Your Honor, it hasn't. I will send the Court a letter.
You could certainly continue with your answer.
The second part would be that in addition to the ex post facto clauses, the fair notice or fair warning decisions of this Court and there are 3 of them. I'd be glad to cite them in the letter that I'm going to write. to the
Mr.
court.
Spear, I'm not going to ask you to rewrite your entire brief, and I'll ask Mr. Townsend to do this as well, but if you send such a letter, it would be very helpful if you could address whether or not Goldenberg is consistent or inconsistent with Burke. That is the position that Justice Abrams seemed to take, that she raised a question, as I recall, as to whether or not Burke is the old 1870 case, Commonwealth against Burke. The site I have is, where are we here? I don't quite have it. It's 1870 in any case.
Yes, I'm familiar with the case, Your Honor, and I will address that in the letter.
Because that may be relevant to...
Well, can you address it now?
Well, I can try to address it. Burke says that when the alleged victim is in a sort of state of stupefaction and doesn't know what is going on, that the force that the statute makes mandatory is satisfied by simply the force that's necessary to effect the sexual intercourse. And I did address this to some extent.
You have addressed that point. I was really saying, assuming that, well, for retroactive application, if there's ambiguity in the law, or appears to be ambiguity, what impact does that have on retroactivity? Because you make the point quite clearly in your brief that the complainant in this case evidenced by many indications that she was not stupefied, that she wasn't asleep, and so on and so forth. Correct?
Yes, I do. That is my response to the Commonwealth's claim on that point. And I would just like, while the Court is on that subject, I'd just like to mention that the Commonwealth has cited a Virginia case, Commonwealth versus Woodward, in support of its claim here. And I just would point out, in the Woodward case, the jury could find that the complainant was completely asleep at the time the intercourse was commenced. And I think that's a big distinction with the situation presented by this case.
You're saying that we could find that she was asleep here?
No, Your Honor.
No, we can't.
In the Virginia case,
Oh,
the
okay.
jury
Sorry,
could
I
find
misunderstood
that the complainant was completely asleep when the intercourse began.
Mr. Spear, was there a crime committed?
I think there was not a crime committed, Your Honor. I will have to think about Your Honor's question about the assault and battery as a lesser included offense. Well,
there was no crime, you say, because of Goldenberg.
That's correct, Your Honor.
Well,
the law of this jurisdiction.
It's partly Goldenberg, but it's also the statute. That is to say,
which specifically requires force, which has been used that language since 1642.
well, the force piece of this, when somebody is, in a deep sleep or incapacitated or has consumed so much alcohol or other substance that he or she doesn't know at all what is going on, it seems to me that that line of cases is consistent with the statute. But when you have, this is essentially a claim of fraudulent inducement, and that it seems to me none of the cases to which the Commonwealth points to that as constituting force. In other words, it might be something else. I don't know whether it's another kind of crime, but it's not force. And to the extent that our statute says you have to have, it must be by force or against her will, that really doesn't go to...
Yes, I think the Commonwealth's position is that the unknowing element, the lack of knowledge as to who it was that the consent to the intercourse is being given, in effect vitiates the consent and should put the case in the same situation as the Burke case. And I will try to address that in the letter that I'm going to write to the Court.
It's going to be a long letter.
I do want to respond to the Commonwealth's claim that this is a special kind of fraud called fraud in the factum. And there are two responses that I want to make to that. First, I think that distinction is completely unknown in our law. That term doesn't appear in any of the Massachusetts cases.
It's really fraud in the inducement.
I think it's fraud in the inducement.
Impersonation.
Yes, I think that's exactly what it is.
It's like an old Shakespeare play.
the fraud in the factum, I cited a case from California that I think explains it very well. It's when a victim is tricked into being the subject of sexual molestation without realizing that he or she is in fact being subjected to a sexual act, which is not the case here.
Yeah, but isn't there a distinction, Mr. Spear, because in Goldenberg the consent was voluntary, albeit obtained by fraud, but she agreed to have intercourse. I mean, that was a voluntary agreement obtained by fraud. Here the agreement was obtained by deception occurring at the time of the act, so it's fraud in the inducement. So there is a distinction, I would think.
Well, I think Goldenberg is an example of fraud in the inducement, where the reason that the alleged victim is induced to consent to intercourse is essentially a false reason. Now, here in the light most favorable to the Commonwealth, and of course, obviously, the defense doesn't concede this to be the fact at trial, but in the light most favorable to the Commonwealth, the defendant would have known that he was being mistaken for his brother before the intercourse began. And I think that would simply be an example of, if that were in fact the case, that would be an example of the kind of misleading on an important point that called the validity of the consent into, of the alleged victim's consent into question, but I don't think would have any impact on the necessary element of force. The Commonwealth, I think, is arguing that the cases that say that obtaining a complainant's acquiescence to sexual intercourse by fraud are better reasons than Goldenberg, and it cites principally, I would say, the case of D, an 1884 case from Ireland, and the State versus Atkins, a 1926 Missouri case. And I want to point out that there are two lines of authority on this. One of them comes from the 1822 English case of Rex versus Jackson, which, like this, is a case of alleged impersonation, and the court there held that fraud can't substitute for the element of force in a rape prosecution. And the other comes from the 1884 case of D, which rejected the Jackson reasoning. And Massachusetts, by the Goldenberg rule, I submit unequivocally falls into the Jackson line of authority, and that's the law as of today. And I think I've covered all the points that I wanted to make, and I've promised to write a letter that hopefully will respond to the various questions.
Mr. Spear, we won't ask you to limit your letter to us being able to read it within 2 minutes and 25 seconds, which you have left. Can I ask you one other thing?
Yes, of course, Your Honor.
We've had cases interpreting it. It strikes me that it is not terribly difficult to amend the statute to take care of these circumstances.
Not at all, Your Honor.
In other words, it's not as if this is one of those highly unusual, not anticipated events.
It certainly isn't.
And many states have, in fact, amended their statutes
Many
provide for a type of...
Numerous states have amended their statutes to either make the conduct that's alleged here rape or some other sexual offense. That is true, Your Honor.
I'm thinking of cases, for example, which may well arise, where somebody engages in sexual intercourse, assuming that the partner is of the other sex, and then discovers afterwards that it's in fact somebody of the same sex. A fairly well-known movie was made about that circumstance. I mean, clearly not who you expected, no suggestion of force. I mean, there are just a number of factual circumstances that don't appear, at least to me, to fit into what this statute provides.
I think a number of the cases that I cited in support of our claim that fraud can't supply the place of force, in a number of those cases, the jurisdiction, the law was changed by statute to reach a different result. But the cases cited was when the law was in the same position it is here in Massachusetts. So,
Thank you, Mr. Spear. Mr. Townsend?
May it please the Court, Thomas Townsend for the Commonwealth. This Court's earliest comments on this issue were in 1886 in the Rusnell decision. And in that case, this Court suggested that fraud could take the place of force in the husband impersonation scenario.
Mr. Townsend, if we adopt your position, tell me what happens in this scenario. If a man tells a woman that he's rich and he's going to marry her, and so she consents to have sexual intercourse with him on those assumptions, but neither is true. He's not rich and he's not planning to marry her. Is that a rape?
That is not a rape.
Well, under your scenario, that would be an inducement to have intercourse that's false and that the man knows is false. And
No, a comparable argument was rejected by this Court in Keevan, which was based upon a sham promise, where the defendant promised that the victim would engage in certain prostitution.
okay, but then how do you distinguish that?
I distinguish it because what we're arguing here is the consent has two components. One, to have sex. Two, with a certain person. Other things such as, I promise to reward you somehow. I promise I'll still love you in the morning.
Right.
That's different than if I'm pretending to be someone else. It's not. It doesn't go to the essence of consent.
Well, it does. The consent was because I will still love you. That was going to be my next question. But I'll still love you in the morning. I'm having intercourse because I love you, and then he takes off at 6 a.m., never to be seen again.
Right.
What is the difference?
The difference is the victim, or the person in that case, would have had sex. She would have known with whom she was having sex. The other things, any kind of inducement, that would have been subsidiary.
Mr. Townsend, how about my hypothetical? There's no question as to who the person is. The person is, Jane Doe, but then it turns out that the person is John Doe.
Right. At the same.
And highly distressing to the complainant. And you're saying that's not this case.
Well, it's not this case, obviously. The facts are different,
it wouldn't reach that circumstance.
I don't think it would, because
so it's only when you mistakenly think that it's Jim and it's in fact John, or it's Jane and it's in fact Janice. You think it's a particular person and it's not that person.
Well, you wouldn't be deceived as to whom that person was. If the person pretended to be a boyfriend or girlfriend, in actuality was not, that would be different. That would be this case. The case you're referring to is separate. It's more in line to the cases just mentioned, where I promise to love you in the morning, I promise to take those kind of things. It doesn't go to the heart or the essence of consent, which, as this Court referenced in the D decision, the judges in D felt that consent had two components. One, to have intercourse. Two, with a certain person. And one of the judges said that the essence of consent is not just the act itself, but the person with whom they're having the intercourse.
Well, if the misrepresentation that's made is as to identity, if someone comes to town and says, I'm the President of the United States, and walks into a bar and says, will you have sex with me? And the other person says, yes. You're the President of the United States.
Yes,
it turns
Mr.
out not
President.
to be.
That would apply only if the person were Laura Bush, because it would be a fraud with respect to one's partner to come in and say, and this has been dealt with. It's an amazing amount of literature that's dealt with this question that has been addressed, and it's been held that is different.
Mr. Townsend, much of your argument makes eminent sense, particularly with the against his or her will, because against your will says, I wasn't willing to have sexual intercourse. The problem is that the statute says by force and against. It's the force piece. And each of the hypotheticals you raise seems to me to be an excellent example of against her will. She did not willingly have sexual intercourse, and they fit into that, but it's the force piece which I think is problematic here.
What I'm asking this Court to do, in which this Court intimated in the Rusnell decision, is that the fraudulent impersonation can substitute for force. And when this Court referenced that in the Rusnell decision, it also referenced the Burke case, which had to do with someone who's in an alcoholic stupor. They cannot consent.
That's different. Yeah.
Right, and the only force necessary, well, this Court grouped all those categories together and said the only force necessary is the force to affect the intercourse itself. It likened the case to where someone is asleep, when someone's in a stupor, when someone is otherwise helpless or have been drugged. That only force necessary is to affect the intercourse.
What about the ex post facto angle? If we overrule Goldenberg. Have you thought about that?
Yes, the standard was set out in this court's decision in the Lewis case in 1983, 81 Mass 411, which dealt away with the year-and-a-day rule in homicide cases. And the court said, "We think a fair solution is to say that the old rule continues to apply to acts antedating a declaration by the court that the rule is vulnerable." In that case, 3 years earlier, this court had called into question the year-and-a-day rule. And so when, in 1980, this court decided the Lewis case, it made the application of the new rule retroactive to the prior rules when it was declared vulnerable in 1977. This court did the same in the Walter R. case in 1993, which rejected the common law presumption of age for rape defendants, which was at 14. 6 years earlier, from that case, this court had called into question whether that was a valid presumption.
Well, when have we called this one into question?
Well, this court in Helfont called Goldenberg into question. This court questioned the two underlying rationales of Goldenberg. It suggested that Goldenberg was not consistent with Berg, and it put everyone on notice that Goldenberg may not still be good law, and that was in 1986. I would ask that this court, if it does overrule Goldenberg, have it apply beginning on August 13th, 1986.
I still have a question.
I thought that was in Justice Abrams' concurrence.
No, Justice Abrams had a concurrence a year later in Commonwealth versus Keevan, where she said that she's again questioned whether Goldenberg was still good law, and she suggested that recent scholarship...
Well, one judge's concurrence wouldn't fit, as you well know, but
Correct.
Helfont was everybody.
Helfont was a unanimous decision.
I still have a question. I'm having a hard time distinguishing. You say that you're looking for a rule that that the two elements are you have sex with a certain person, but I still don't see how you distinguish the with a certain person when it's someone other than who you think it is. What's that? How does that differ from somebody making a false promise? I don't see analytically how it differs.
Well, it's still...
They're making a false statement as to who they are, or a false statement that they'll marry them. What is the difference,
Right.
really?
And there are plenty of scenarios where someone promised they will
Right.
marry them. There's no discrepancy or no mistake as to whom that person is having sex with. And under the better definitions of consent, the definition that the trial judge in this case employed and that the judges in the D decision employed, is that consent, one of the essential components of consent is the identity of the person with whom they're
But
consenting.
we're talking force. That's what we're focusing on is force,
And
not consent.
So you're saying if consent is vitiated, then we revert to the Burke analysis. The person should be deemed as if they were unconscious or incapable of consent, and then we only look to the force necessary to commit.
Correct, and that's what this court did in Rusnell. Rusnell grouped together the Burke analyses, included husband impersonation among those categories, and indicated that the only force would be necessary would be the force to effect the penetration. Goldenberg...
If we looked at the legislative history of the statute, rape statute, when they talk about force, what would we find?
Well, it is legislative history. The statute was enacted first in 1642 and has remained largely unchanged.
And the
over that.
Goldenberg decision has been on the books for a long time, and the legislature has known full well what it is, how that has been interpreted, and it's not a difficult statute to fix.
Correct, but we're dealing with a common law crime, and the legislature has seen fit in its wisdom to allow this court to determine the contours of the common law, whether it be rape, whether it be murder.
Of course,
Goldenberg,
and when we get it, when we interpret it, I mean, I'm not saying that we can't revisit it. So
Right.
that's not my question. My question is, I'm still looking at the statute.
right. and
Mr.
this-
Townsend, how do you deal with Mr. Spear's argument that there were two lines and that you keep relying on the D case, and that was rejected in our law?
Well, there are two lines of authority, and the D decision was quoted and cited with apparent approval by this court in Rusnell, and that's why I've relied on to it such an extent. Of the two lines of authority, I believe that the one more consistent with the principles of criminal law, as a view shared by Judge Thomas Cooley, one of the best judges this nation has ever produced, is that under this scenario where one impersonates someone's husband, the crime of rape occurred. Goldenberg, one of the rationales underlying Goldenberg, one of the rationales that Justice Abrams had such trouble with, is that it said that the essence of the crime of rape was not the intercourse itself, but the outrage upon the feelings of the victim. And that in the impersonation scenario, the outrage is not as great as it is with forceful penetration. There's two problems with that. One, Justice Abrams said, that is not in line with Burke. Burke had said that there can be rape even if someone is unconscious. So someone may not have any outrage, may not even know that she had been raped, but still that would be rape. But under the Goldenberg scenario, it wouldn't be. Another problem with the Goldenberg is that it's not even valid. Just looking at this case, after the woman found out that it was her brother-in-law, or her boyfriend's brother, they were married for all intents and purposes, she and her boyfriend. After she found out it was his brother whom she had sex with, she, by her own admission, freaked out. She chased him up the stairs. She ran after him. She
There's
screamed.
no question here that there was evidence that she was deeply disturbed by what had happened.
But that's one of the underlying rationales, perhaps the primary rationale of Goldenberg.
Well,
is
that's
that
why I
there's no
asked you about
outrage.
the transgender situation, because I can imagine that those might be extremely disturbing circumstances as well. And you're insistent that we limit it only to identity seems to me, again, to be not sustainable. You either look at the outrage or you don't look at the outrage. And then if you look at the outrage, as Justice Cowan has suggested, there are many circumstances where somebody might be very outraged.
Right, for that reason, if we look at the outrage, Goldenberg, it was an incorrect presumption to think the outrage was any less. But also it was incorrect to focus on the outrage instead of the act and the fraud itself.
Well, the legislature clearly isn't focusing on the outrage.
Right. The statute has remained largely unchanged, and there's no outrage element. And when judges charge juries, they don't charge on the outrage. And that's one of the problems with the Goldenberg premise, which went against this course prior as Spousal and Rusnell.
Mr. Townsend, may I ask you this question? Mr. Speer does reference a number of courts that have interpreted the force piece as not being satisfied by fraud with respect to identity. Let's just leave it with identity. And then in some states, they have changed the rape statute accordingly to deal with that. Are there any cases where a court, using its common law powers or even its statutory interpretive powers, has reversed itself? In other words, the statute hasn't changed. There was a Goldenberg ruling, no change in the statute, and the court then reversed itself.
I don't know if there's been any cases under that scenario. There have been cases where court has held that the fraud can be the substitute for force.
No, I know that.
Right.
I know
but
that.
I don't know of one which has made a Goldenberg-type decision and then came back to revisit it and reversed itself. I'm unaware.
Can you send us in a letter on your version of the ex post facto
Certainly.
point?
Certainly. And I can address those other issues as well that were raised.
And I take it that part of what you will do is argue that the Rusnell case, that Goldenberg is inconsistent with earlier case law.
Right, and I make that at some length in my
Rusnell,
brief.
I guess it is.
And I would ask that this court overrule Goldenberg, apply it to this defendant, and restore rape by fraud to the limited court categories as contained in the Rusnell decision. Thank you.
Thank you, Mr. Townsend.